Hello Year 12s and welcome to this video on express rights. There are 4 things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video so that you can take notes. Use the rewind function if you need to go over any information contained in this video. The third thing that you need to do is to have your summary books open in front of you. I have indicated on the relevant slides the information that you need to include in your summary books. And the fourth thing that you need to do is have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of important terms or of any other words, the meaning of which you're unfamiliar with. Once you've finished watching this video, please read the section of the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that information.
On this slide, I've set out your learning intention for this video. This learning intention is that you should be able to describe the 5 express rights in the Australian Constitution. Make sure that you write this learning intention down in your Cornell notes. Keep an eye out for the definitions of the terms that are included on this slide.
These are the definitions that you'll need to include in your vocabulary sheets. Now, many of you will have heard of the United States Bill of Rights. A Bill of Rights is a document that sets out the rights of individuals. In the case of the United States Bill of Rights, some of the rights that individuals have include the right to bear arms, that is, the right to own a gun, the right to freedom of religion, the right to freedom of speech, and the right to trial by jury. The United States Bill of Rights is actually included in the United States Constitution. Where individual rights are included in a constitution, we refer to those rights as entrenched rights. The significance of this is that because the rights are included in a constitution, it is much harder to change those rights. The reason for that is that a constitution can typically not be changed simply by an act of Parliament.
For example, our Constitution can't be changed just by the Commonwealth Parliament passing an amending act. Instead, for any change to our Constitution to come into effect, that change needs to be approved not just by the Commonwealth Parliament, but also by Australian voters. Specifically, under Section 128 of our Constitution, the Australian Constitution can only be changed if that change is approved both by the majority of voters in Australia and by the majority of voters in the majority of states.
Therefore, by including rights in a constitution, we are giving those rights special protection. Parliament can't simply change those rights by itself. Now, there are many other countries besides the United States that have bills of rights that are included in their constitutions. Examples include Canada and South Africa. However, Australia does not have a Bill of Rights, and our Constitution does not include a Bill of Rights.
Nonetheless, our Constitution does include some rights which we call express rights. As we'll see, these are not rights that are given to individuals, but instead are restrictions on Parliament in the exercise of its lawmaking powers. Let's now look at these rights.
There are 5 express rights that are contained in the Australian Constitution. An express right is a right that is set out in a constitution. That is, you can read it in the Constitution. As I've explained before, where a right is included in a constitution, the only way that it can be changed or removed is by amending or changing the Constitution. There are 5 express rights which are included in our Constitution, and these rights can only be changed or removed through the Section 128 process. Because of the double majority requirement, it's very difficult to amend our Constitution, and therefore it's very difficult to amend or take away these 5 express rights. Now, Unlike countries such as the United States of America, South Africa, and Canada, the 5 express rights in our Constitution are not rights that are given directly to individuals. If you are a citizen of the United States Bill of Rights says that you personally have the right to, for example, freedom of speech. No government, no parliament can take that right away from you. However, under our Constitution, the 5 express rights are not expressed as rights that are given directly to individuals, but instead they are expressed as restrictions on the power of Parliament to make laws. That is, our Constitution includes 5 provisions that in various ways restrict the Commonwealth Parliament in the kinds of laws that it can make. And those restrictions are designed to protect individual rights. So as I've said on the slide, the 5 express rights in the Australian Constitution are protected because Parliament cannot pass laws that infringe these rights. That's why we say that these rights are indirectly protected rather than directly protected. They're indirectly protected because the Australian Constitution includes restrictions on the power of Parliament to make laws that infringe those rights. They're not directly protected because those rights are not given directly to individuals, as in the case of the United States Bill of Rights. Let's now turn to look at each of these express rights. I'd like you to have your constitutions in front of you so that you can read what these rights are. The first right that I want to look at is contained in Section 116 of our Constitution. Section 116 says that the Commonwealth Parliament cannot make any laws that establish a religion, impose any religious observance, or prohibit the free exercise of any religion. Look at the way that Section 116 is worded. It doesn't say that each person has the right to freedom of religion. In the United States Bill of Rights would say something like that. That is, that every person who's a citizen of the United States has freedom of religion. But that's not what Section 116 says. Section 116 says that the Commonwealth Parliament cannot make a law that requires people to follow a religion or that prohibits people from following a religion. So Section 116 is a restriction on the law-making power of the Commonwealth Parliament. Now, note that this is only a restriction on the Commonwealth Parliament. The state parliaments could, at least in theory, make laws that do interfere with religious freedom. So the Victorian Parliament tomorrow could pass a law that required everyone to be a Buddhist, or that prohibited anyone from being a Christian. They could do that. But the reason they don't do that is because
they know that if they passed such a law, or even suggested such a law, then the members of Parliament who supported that kind of law would be likely to be voted out of office at the next election.
So when we talk about a right to freedom of religion, it's not a right that is given directly to individuals. It's a right that arises because, in this case, the Commonwealth Parliament is prohibited by our Constitution from making laws that affect the freedom of religion. Let's turn now to the second express right that is contained in our Constitution. This is the right to trial by jury, and it can be found in Section 80. So please open up your constitutions to Section 80. Now, Section 80 contains a lot of words, but effectively what it says is that trials for indictable Commonwealth offences, that is, for more serious criminal offences created under Commonwealth law, trials for indictable Commonwealth offences must be jury trials. Put another way, if you are accused of committing an indictable Commonwealth offence, such as a terrorism offence, then you have the right to a trial by jury, not a trial by a judge alone. Now again, look at the way this is framed. It doesn't actually confer on individuals the right to a trial by jury, but Section 80 tells the Commonwealth Parliament that it can't pass legislation under which an indictable Commonwealth offence is tried by a judge alone. There must always be a jury. As with Section 116, this is only a restriction on the Commonwealth Parliament. The state parliaments could quite validly pass a law that says that where a person has been accused of an indictable offence in that state, so for example in Victoria, indictable offences created by the Crimes Act of Victoria include murder and rape, where a person has been accused and is being tried for one of those kinds of offences, the Victorian Parliament could pass a law that says that the accused is only entitled to be tried by a judge, that is, without a jury. Again, the reason the state parliaments don't do that is because if people felt very strongly about the right to trial by jury,
then at the next election, the members of Parliament who voted for that law may well be voted out of office. So, when we talk about a right to trial by jury, it's not a right that is given directly to individuals. It's a right that arises because, in this case, the Commonwealth Parliament is prohibited by our Constitution from making laws that take away a person's right to trial by jury where they have been charged with a Commonwealth indictable offence.
That brings us to the third express right, which is included in the Constitution. And you'll find this express right in section 51(31). Now remember your Roman numerals, 31 is XXXI. The way we always read section 51 when we're looking at any of the subsections is to start off by saying the Commonwealth Parliament has the power to make laws in respect of. Now we turn to subsection 31 and it says the acquisition of property on just terms. Put another way, the Commonwealth Parliament has the power to make a law for the compulsory acquisition of property, that is, for taking away your property without your consent. But that law will only be a valid law if it provides for that acquisition to be on just terms. That is, the Commonwealth must pay you fair and reasonable compensation. To give you an example, if the Commonwealth Parliament passed a law for the building of an airport,
and for the purposes of building that airport, it was necessary to take over an area where there were houses,
the Commonwealth Parliament could pass a law
under which the Commonwealth Government compulsorily acquired your house.
Nothing you can do about it.
However, what you are entitled to is
fair and reasonable compensation for your house. So your house can be taken away, but instead you get the monetary value of your house. Now again, like section 116 and like section 80, this is only a restriction on the Commonwealth Parliament. The Victorian Parliament, for example, could pass a law tomorrow
under which the Victorian government compulsorily acquired
your house in Victoria. And they could do that without having to pay you compensation.
Now, again, the only reason a state parliament, in our case the Victorian Parliament, doesn't pass such a law is you can imagine that if they passed a law that enabled the acquisition of people's houses without paying any compensation, that would be something that voters would regard very dimly. And at the next election, they would probably vote out of office those members of Parliament who voted in favour of the law. So, when we talk about a right to compensation for compulsory acquisition of property, it's not a right that is given directly to individuals. It's a right that arises because, in this case, the Commonwealth Parliament is prohibited by our Constitution from making laws that take away a person's property without also giving that person reasonable compensation for that property.
Only two more express rights to go. Now these last two express rights are rather complicated, so I'm going to explain them to you.
But I suggest that you concentrate on the first three express rights that we've looked at. That is, you must be able to explain the first three express rights in some detail. You still need to know that there are 5 express rights, but the most important thing you need to know about these other 2 express rights is that, unlike the first 3 express rights, these rights restrict the lawmaking power not just of the Commonwealth Parliament, but also the lawmaking powers of the state parliaments. In other words, unlike the first 3 express rights, these 2 remaining express rights apply not just to the Commonwealth Parliament, but also to the state parliaments.
All right, well, our fourth express right is the right to free interstate trade. This is contained in Section 92 of the Constitution. So please open up your constitutions to Section 92. And we'll concentrate here on the first paragraph, which says that on the imposition of uniform duties of customs, that is, way back in the early 1900s, trade, commerce, and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. There's a lot of old-fashioned language in that, but what that boils down to is that Section 92 says that trade and commerce between the states, which is what interstate trade and commerce is, it says that trade and commerce between the states must be free. Well, what does this mean? The best way of answering this question is to think about when interstate trade and commerce is not free, so that Section 92 will be breached. Interstate trade and commerce will not be free if a law discriminates in favour of trade within a state, that is intrastate trade, and against trade between states, that is interstate trade. Let's illustrate that with an example. Suppose the Victorian Parliament were to impose a tax on goods that were imported from New South Wales into Victoria. Now, that law that the Victorian Parliament had made would breach Section 92, that is the right to free interstate trade, if that same tax was not also imposed on goods that were made within Victoria. And that's because such a law would discriminate in favour of goods made in Victoria, that is, they didn't face this tax, but would discriminate against trade between New South Wales and Victoria because that tax was imposed only on goods imported into Victoria from New South Wales. Now, unlike the first 3 rights that we've looked at, this restriction contained in Section 92 is a restriction on both the Commonwealth and the state parliaments. That is, neither the Commonwealth Parliament nor a state parliament can make a law that results in interstate trade being discriminated against compared to intrastate trade.
Having said this, Section 92 doesn't make all laws invalid that discriminate against interstate trade. If there is a very good reason for a law to discriminate against interstate trade, then that law will be valid even though it discriminates against interstate trade.
So, for example, we do have laws that prohibit the importation from one state into another of various goods, such as fruit. And the reason for that is to stop the spread of disease from one state to another. Now, in that case, it is absolutely true that the law discriminates against interstate trade because, for example, the Victorian law may ban the importation of oranges from New South Wales into Victoria. That is clearly discriminatory. However, if the purpose of that law is not really to discriminate against New South Wales trade, but is really to protect Victoria from the possibility of disease coming in the oranges that New South Wales is sending to Victoria, then that law is valid. That is, it's considered not to breach Section 92. That then brings us to the fifth and final express right that is included in the Australian Constitution, and this is the right not to be discriminated against because of state of residence. This right is found in Section 117, so please turn to that section in your constitutions. You'll see that Section 117 says that a resident in any state shall not be subject in any other state to any disability or discrimination which would not be equally applicable to them if they were a resident in that other state. Quite a lot of words, isn't it? Let's see if we can simplify that. Another way of putting this is that Section 117 says that it's unlawful for a state to discriminate against an individual because that individual resides in, that is, lives in, another state. An example might help. Suppose that the Queensland Parliament passed a law that prohibited people who lived in another state from practicing law in Queensland. That would be an example of a law that breaches Section 117. This is because people who live in Queensland are permitted to practice law in Queensland, but a person who lives in another state, for example New South Wales, is prohibited by that law from practicing law in Queensland. You might think this sounds a rather strange sort of law, but as a matter of fact, many lawyers do fly from one state to another state and practice law in those states. So this is actually quite a real-life example. Now in that case, as I've said, that law would be invalid because it discriminated against people who live in, say, New South Wales on the basis of the fact that they live in New South Wales. People who live in Queensland can practice law in Queensland. People who live in New South Wales would be prohibited by that law from practicing law in Queensland. Like Section 92, Section 117 is a restriction on both the Commonwealth and the state parliaments. That is, neither the Commonwealth Parliament nor any state parliament is allowed to make a law that discriminates against a person because that person lives in another state. However, there are a number of laws that look as though they discriminate against people because of the state in which they live, but which are actually valid, that is, they don't breach Section 117.
Because they have a legitimate purpose for treating people who live in another state differently.
An example is that there are laws in all of the states, for example, such as in Victoria, which say that the only people who can vote in Victorian elections are people who live in Victoria. Now, in one sense, that's discriminatory because if you live in New South Wales, you're not allowed to vote in a Victorian election. However, the purpose of that law is not really to be discriminatory, but it's simply there to ensure that the only people who can elect a Victorian government are people who live in Victoria. And that makes sense because the Victorian government governs for Victorians. It governs Victoria. It doesn't govern for people who live in New South Wales.
Now let me repeat, these last two express rights, that is, the right to freedom of interstate trade in Section 92 and the right not to be discriminated against because of state of residence in Section 117, these last two express rights are quite complicated and you don't have to be able to describe them in any detail. But you do need to know that, unlike the other three express rights, which you do need to be able to describe in detail, these last two express rights limit the power of both the Commonwealth Parliament and the state parliaments to make laws. So never write in a SAC or exam that the express rights only restrict the lawmaking powers of the Commonwealth Parliament. While the first three express rights only restrict the lawmaking powers of the Commonwealth Parliament, the last two express rights restrict the lawmaking powers of both the Commonwealth Parliament and the state parliaments.
Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to describe the 5 express rights in the Australian Constitution. Remember that you now need to read the section from the textbook referred to on the first slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.